It's a long route to get there historically and in every other fashion. But I want to spend a little time getting there so that we have a pretty good sense about how we got to the point where these sorts of things happen and really how we got there. So if you will, spend a little time with me before, and I'm going to take you back in history, and to talk to you a little bit about marriage. Marriage has traditionally been seen to embody three elements historically: its sacramental nature, its contribution to the common good, and its contractual nature. Today, all three of these elements have been eliminated and have been replaced with a no-fault individual right notion of marriage. A natural consequence of marriage becoming a no-fault enterprise is that the endurance of a marriage lacks merit from a legal standpoint. In short, marriage today, with its oft-resultant dissolution, is legally viewed as being out of the control of the parties to the marriage. To paraphrase Dickens, it's nobody's fault. Such a view of marriage and its dissolution are certainly appropriate if indeed marriage is of no value to society, and if the dissolution of marriage is nobody's fault. However, this legally imposed view of marriage frustrates two significant groups of people: those who want to attach more importance to marriage, and those who think that fault should be used in determining how separation and divorce are handled. Simply put, no-fault divorce prevents those who do attach greater meaning when they enter into marriages, and who fill their marriage with such meaning, from benefiting from their actions. Today's no-fault system imposes a one-size-fits-all perspective on marriage, which translates into a belief that a healthy, happy marriage is not a result of effort and choice. As if such a burden were not enough, the no-fault system does much more. Insofar as no-fault encourages divorce and the consequence of such, it imposes on married persons and never married persons the social burdens spawned by divorce. Although this may be the most significant cost to those persons, it is not all that they must bear. In addition, a tax is actually levied on families across society to cover the costs of the numerous marital dissolutions in this country. Finally, no fault forces those who fall into its grasp to act in every way as if nobody is at fault. As Bay has told you, parents of divorce are not free to talk to their children about the fault in their marriage. And the innocent spouse is in fact told that no matter what they committed to the marriage, no matter what they gave up for their children, that they need to move on with their lives. It is nobody's fault. Today I want to explore the history of marriage a little bit with you and show how the modern no-fault view fits into this historical setting. And in order to do this, we need to talk about the permanency perspective, the common good perspective, and the individual good perspective. Let's go back a little bit and think about how marriage sprung up in Western civilization to which we're the heirs. Marriage in America originated in the Catholic Church's view of marriage. The Catholic Church historically had determined the nature and manner of marriage in virtually all of Europe for hundreds of years. The view of marriage held by the Catholic Church is, I think, best set forth in the Roman Catholic Catechism of 1566 from the Council of Trent. And this is how they define marriage. Marriage is defined as a conjugal union of man and woman contracted between two qualified persons, which obligates them to live together throughout life. A perfect marital contract requires internal consent, external compact expressed by words, the obligation and tie which arise from the contract, and the marriage debt by which it is consummated. Consent alone is not enough for marriage. There must be mutual agreement, freely entered into and declared in words stated in the present tense, one to the other. The marriage promise is not a mere promise, but a transfer of right by which the man actually yields of the dominion of his body to the woman the dominion of her body to the man. Interestingly, as late as 1885, the Supreme Court affirmed this view of marriage. Think about it. The highest court in the United States said this about marriage in 1885. For certainly no legislation can be supposed more wholesome and necessary in the founding of a free, self-governing commonwealth, fit to take rank as one of the coordinate states of the Union, than that which seeks to establish it on the basis of the idea of the family as consisting in and springing from the union for life of one man and one woman in the holy estate of matrimony, the sure foundation of all that is stable and noble in our civilization, the best guarantee of that reverent morality which is the source of all beneficent progress in social and political improvement. Shortly thereafter, the Supreme Court again said this: marriage creates the most important relation in life. It has more to do with the morals and civilization of a people than any other institution. It has always been subject to the control of the legislature and decides various aspects about it. And the court says this: it is also to be observed that while marriage is often termed by text writers and in decision of courts as a civil contract, generally to indicate that it must be founded upon the agreement of the parties and does not require any religious ceremony for its solemnization, it is something more than a mere contract. The consent of the parties is, of course, essential to its existence. But when the contract to marry is executed by marriage, a relation between the parties is created which they cannot change. Other contracts may be modified, restricted, or enlarged, or entirely released upon the consent of the parties. Not so with marriage. The relation once formed, the law steps in and holds the parties to various obligations and liabilities. It is an institution in the maintenance of which, in its purity, the public is deeply interested. For it is the foundation of the family and of society, without which there would be neither civilization nor progress. Thus, the view of marriage entertained by the Supreme Court, at least up until the late 1800s, is not far different, if different at all, than the position taken by the Catholic Church over 300 years earlier. It should also be understood that for hundreds of years, the power over marriage was actually confined to ecclesiastical courts. The ecclesiastical courts in the Catholic Church had actually been tasked with giving the determinations with regard to marriage. Ecclesiastical courts are unique in that they confront issues that go to the heart of the Church's supernatural nature, such as the sacramentality of the marital bond. These ecclesiastical courts actually find their role, sort of for Catholics, in Christ himself. Simply put, the view of the Church is that in instituting the Church as a perfect society, distinct from the civil power and entirely independent of it, Christ gave her legislative, judicial, and executive power to be exercised over her members without any interference on the part of the civil society. In fact, in the early years of the Church, it was common for Christians to go before the bishop and accept his decision, even upon merely civil matters, when a controversy arose. Eventually, around the time of Constantine, Catholics were allowed to appear before the civil magistrates. Nevertheless, even today, the Code of Canon Law states, quote, "The marriage of Catholics, even if only one party is a Catholic, is governed not only by divine law, but also by canon law, without prejudice to the competence of the civil authority in respect of the merely civil effects of the marriage. The civil tribunals had no authority to deal with a relationship that was foreign to their jurisdiction, ever since it has been raised to the level of a sacrament by Christ. Moreover, the civil society continues to recognize the special role of churches in this area. They allow marriage to be taken place by ministers in churches. For a long time, then, the nature of marriage was determined solely by the ecclesiastical courts, and it was not determined by civil courts. So for hundreds of years throughout all of Europe, the ecclesiastical courts had the sole jurisdiction over marriage. One of the first significant steps in changing this was in England shortly after the time of Henry VIII. Well, actually, about 100 years after the time of Henry VIII. In 1857, Parliament created a private divorce act. And this private divorce act allowed, now for the first time, divorce to be part of parliamentary business. It's important to see that when the ecclesiastical courts were taken out of the equation, what the society did is it actually gave the power over divorce to legislatures. It didn't go into a civil court system at first. And even in the United States, up until about the mid-1800s, divorce was handled as a matter of legislative act. In fact, we have a term that we use that's still in use today when we talk about divorce. We talk about a bill of divorce. You think that's a strange thing. Is that what I get from my lawyer? No, the bill of divorce was the legislative act that was passed by the legislature to allow a divorce. In other words, marriage was seen as so important for the good of society that you could only be allowed to divorce if the legislature thought that the good of society was promoted by the divorce itself. So it was a very cumbersome system. And this only occurred in about in England in 1857, the 1800s, and in America in the middle of the 1800s, the states also gave it to the civil jurisdiction. This was a procedural change. Okay? So you have to think about the procedural changes that are taking place, and then we need to talk about a major substantive change. The most significant substantive change in marriage began under the influence of the Reformation, because fault, in its present context that it's still talked about in America, at least with regard to no fault, was actually a consequence of the Reformers' reaction to the concept of indissolubility that the Catholics had had. So what happened is, as a consequence of the Reformation, a significant change took place substantively in marriage. And in many ways, I think this was the most critical change that occurred with regard to marriage, maybe in the history of civilization. Because once marriage was stripped of its indissoluble nature, no merit can be seen in maintaining some marriages, right? There are going to be some marriages where people will say, well, there's not really, since there's no indissoluble nature of it, let's find some fault. For instance, childless adults who want to divorce don't harm the common good of children being raised in separate households if they're allowed to divorce. So the hard cases then begin to be used as a wedge to question the state's interest in marriage in general, okay? Because you can always find the hard case, and these become the wedges. Ultimately, once fault is introduced, it naturally broadens to encompass other cases in which the state has probably a pretty strong interest. One author has written this, quote, "Once it is granted that divorce should be allowed for the hard cases, there is no way of avoiding the logical conclusion of widespread divorce. Because of the manner in which the human race is interlocked, an individual's conduct becomes a pattern for others. Not many years ago, the law finally took compassion on the misery of mismated marriages, usurped jurisdiction, and granted a divorce, but at the same time announced that this action was only on the strictest of grounds. Either those strict grounds were maintained, or the grounds broke down until divorce could be granted when one of the couples eats apples in bed. Once divorce has succeeded in putting its wedge into society, there can be no halting its cleavage." Once the concept of fault divorce took hold, the idea of marriage as a mere contract, and therefore as simply a private good, began to surface in discussions of marriage and divorce. And these concepts began to influence marriage itself. So what you have is this movement from a permanent state to a state of fault to then a state of sort of contract at will. The divorce system in early America had very limited grounds for divorce on the basis one fault was introduced. The original two cases were what? Adultery and desertion, both sort of major significant issues. And these existed in the American system for a long, long period of time. However, as the nature of these things goes, as the 19th century closed and the 20th was in its infancy, divorce expanded in a critically important way. One of the new key grounds for divorce was based upon cruelty. Initially, the term cruelty was based upon objective events, acts giving actual physical pain, as distinguished from mental suffering. However, cruelty quickly became the preferred ground for couples seeking a divorce. How do you prove it or disprove it? He was mean to me, that's cruel. And this term was interpreted with great latitude. Again, an author writes, although adultery and desertion are pretty objective facts, right? Either somebody was involved in adultery or they deserted you. You can test that objectively. Cruelty encompassed a wide spectrum of offenses. In its strict construction, cruelty was restricted to physical violence that went beyond the limits of moderate correction. Think about that in today's world. And actually threatened the life or health of the victim. In the divorce courts of the South, amazingly, this limited definition was progressively eroded and discarded. Verbal violence and threats began to be included, as were general insults and imputations of immorality. The expansion of the meaning of cruelty eventually allowed almost anything deemed so by the pleader to serve as cruelty. By 1949, think about this, 1900 it's introduced. By 1949, cruelty accounted for 2/3 of all divorces in the United States, compared to 1/8 of divorces in 1870. So to the degree it existed before then, it was 1/8. The term itself became a mere anachronism of the law, whose meaning became capable of serving to allow divorce by desire. With the extension of the meaning of cruelty beyond notions of the public peace, the state seceded any extrinsic control over marriage. Consequently, right before no fault comes in, divorce was based upon adultery, desertion, and cruelty. And those were the system. However, there was one state that held the line on all of this, and that was in New York. During all of this, New York actually held the line. It's surprising today. We don't think about that. Catholic New York, though, back in the 18 and 1900s. And as a consequence, New York had the lowest divorce rate of any state in the Union. It's an interesting thing. No one would think about it today. The rise of the 20th century phenomenon of no-fault divorce should not be surprising in light of the preceding discussion, right? I've laid it out. That's how it took place.